defendant killed his best friend.
All right, Mr. Lewis, if you can remove your props and if you can move the podium.
Where would you like the podium, Your Honor?
Just push it out of the way for me, please. In just a moment, I'm going to instruct the jury on the law. No one will be permitted to enter or leave the courtroom while I am giving these instructions. They are lengthy, so if you want to leave, please leave now.
All right, they are done with closing arguments. Still with us to help break this down, litigation attorney Sonny Slaughter and Rich Schoenstein. Rich, let me start with you because this is a case where really only two people know what happened, the defendant and the deceased. We don't know for sure whether or not it was a suicide, a murder, an assisted suicide. This is the decision for the jury. But Rich, how well do you think the prosecution has presented their case to convince the jury that this defendant was involved in her death?
So I didn't get to see all of the evidence in this case as it unfolded, but I did see the closing arguments, and I did like the prosecution's closing argument very much. First of all, I just liked his style. I liked the way that he addressed the jury. He spoke directly to the jury. He didn't use a lot of notes. And essentially, his theory boils down to that the defense's argument is not possible, that the way the gun shot had to be the defendant shooting it rather than the victim shooting it, because she would have had to hold the gun at a very awkward angle, a certain distance from her own head, and use her thumb to pull the trigger. And it's highly unlikely that she did that. I mean, extremely unlikely that she did that. And also, there's not much other evidence in this case of her being suicidal other than the defendant's point of view. So I think they've painted a pretty strong case, but it does leave some room because, Judge, as you said, there's nobody there. There's no film of this. We don't know for sure what happened. So there is a little room for someone on that jury to come up with reasonable doubt.
But I love, you just made the point that it was a very effective closing argument, because to your point, for you, Rich, to be able to listen to the closing argument and pull all of that out of it, that's what a closing argument should be, right? To put it all together for the jury. So I loved your remarks on that. Sonny, add this to the fact pattern, though, that we know the medical examiner during the course of this trial did testify that this gunshot wound could have been self-inflicted, or it could not have been self-inflicted. And if I were the defense, I think I'd hang my hat on that, because to me, that is enough to say reasonable doubt. Even the medical examiner cannot say what happened.
Right. And because the medical examiner can't say it, and because they did not do any swabs, and I was listening earlier that they did not test the hands as something that they no longer do, I think since 2013, she said, in Georgia, because it's not reliable, then the jury will have to rely on all of the other information that they have heard, even though the defendant says that his testimony was coerced. You have to, law enforcement had to have had put together a very tight case and a timeline based on digital footprint, based on other evidence, and based on the fact that he was present. And he says he was present because he didn't do it. So tying all those knots and, things together would make it probable. But once again, there is still reasonable doubt, and that is going to be something that the jury is going to have to really think long and hard about before they sentence this young man to potentially a sentence that, and he might not be guilty.
Right. All right, Rich, what do you think of the defense's decision not to present any evidence? We also know the defendant did not take the stand. Just based on what you know about the fact pattern, the closing arguments, do you think strategically that is a good move by the defense in some instances like this one?
It very well could be. I don't know the answer to the question, what would this defendant have been like had he testified? And presumably his lawyers do know that, because they would have practiced with him. they would have given it a dry run, and they may have concluded that he wouldn't be a very good defendant on the stand. It may be that there's too much ammunition to cross-examine him on, and the defense probably made the decision that the prosecution case has enough fragility to it. There's enough space to go after that reasonable doubt, as Sonny was saying, that they don't need his testimony, and therefore his testimony is too risky, so they don't put him on.
Yeah.
And I can see that as a defensible decision by his lawyers.
And what a great point you make is that you, as the attorneys, do know what the risks are, what they would be like on the stand. You take all of that into account before advising them. And I have to say, Sonny and Rich, as litigation attorneys, did you appreciate as much as I did, finally, during closing arguments, we see the use of demonstrative aids, the gun, the head. I mean, these are things that really bring it home to a jury. We don't always see it, but we did in this case. All right, stay tuned. We are going to take you to Florida next for the roommate romance murder trial. The defense calls its only witness. Will it be the defendant? Stay tuned.
Tonight on Closing Argument.